Welcome back to the Deep Dive. Today we're plunging into a really fascinating and fast-moving area where tech meets law. We're talking blockchain, digital contracts, and how they're kind of shaking up our whole idea of what law even is. The big question we're digging into is code actually becoming a new kind of law? And what does that mean for all of us? For this deep dive, we've looked at some really insightful stuff, analyses on this idea of on-chain law, the smart contract tech behind it, and also a very recent, pretty major court case that's making waves in the DeFi world.
Right. And our goal today is simple. We want you to leave with a really clear picture of what on-chain law is all about, how it's different from, the legal systems we use every day, the huge potential of smart contracts, and then crucially, the real-world bumps and challenges that pop up when these digital systems meet traditional law. So you'll get not just what's happening, but why it's a big deal and what questions you should be thinking about.
Okay, let's unpack this then. On-chain law. It sounds like a whole new way to think about rules and governance, right?
It really is. I mean, think about regular law, common law, civil law, whatever system. They get their authority from somewhere specific, like courts making decisions or governments passing laws. And really importantly, they depend on people or institutions to make sure rules are followed. Police, courts, the state itself, intermediaries. On-chain law, though, it's built differently. The law isn't written by politicians. It is the open source code of the blockchain network. Think Ethereum, Cardano, Near. The rules for things like DAOs, Decentralized Autonomous Organizations, are set and actually enforced by that code. And here's the kicker. There's no need for those traditional guarantors. Smart contracts, these consensus algorithms, they're designed to run themselves, autonomous, self-regulating.
Wow, okay, so that's a huge shift. Instead of trusting human institutions, which can be slow or biased, you're trusting math. Verifiable code and encryption to enforce agreements. Is that the core idea?
That's a great way to put it. The authority and the enforcement mechanism change completely. And the engine driving this are smart contracts. Nick Szabo came up with the concept way back in the mid-90s. He called them a set of promises specified in digital form, including protocols within which the parties perform on these promises. Basically think, if-then-else logic. If this happens, then the contract automatically does that.
Okay, so if-then-else. But what makes them really, groundbreaking? They sound powerful.
Well, the two big properties are that they're self-executing and immutable.
Self-executing and immutable.
Right.
Imagine writing an agreement and it just runs itself. No lawyers needed to check things, no banks to move money. It just happens. And immutable means once it's deployed on the blockchain, it generally can't be changed.
Okay, that is interesting, like a vending machine. You put the money in, press the button. Exactly. That's a simple, classic analogy. If the money's right, then the soda drops. No negotiation, no human cashier needed for that specific transaction. And blockchain tech is what really gives smart contracts their power, their jet fuel, so to speak. Because the blockchain provides this distributed way to monitor things, agree on what's true, that's consensus, and keep it all secure with cryptography. It makes them reliable. So the basic life cycle is 1, code the terms. 2, get it validated and put on the distributed ledger. 3, connect it to any needed real-world data, like, say, weather info for insurance. And 4, based on that data and the rules, it either executes, pays out, transfers ownership, whatever, or it expires.
The efficiency gains seem obvious there. Less paperwork, fewer delays.
Absolutely. Economists talk about transaction cost, right? The cost of making any exchange happen. Smart contracts aim to slash those, especially the cost of enforcing the deal. For banks or big companies, that could mean lower operating costs, maybe better ways to manage risk. For you, the consumer, maybe cheaper services, faster payouts, maybe even access to things that were just too complex or expensive before.
Like that flight insurance example you sometimes hear about.
Precisely. Flight delayed over 2 hours. The contract checks the flight data automatically, then sends the payout. No forms, no waiting weeks. It's about trust through code, not intermediaries.
Okay, that vision makes sense. But let's get practical. These on-chain projects, DeFi platforms, exchanges, games, they still have the same basic needs as a regular business, right? Stakeholders, money, making decisions, governance.
They do. The core pillars are similar: stakeholding, treasury, governance. But how they're structured on-chain is different. Instead of shares, you have tokens for stakeholding. Instead of a bank account, you have crypto wallets for the treasury, no bank needed there, and governance. Instead of a board of directors making decisions, you often have token holders voting via smart contracts, and the outcome gets executed automatically.
So given all that, do these projects still need traditional legal companies today? Or can they exist purely on-chain?
That's the million-dollar question, maybe even the trillion-dollar one. In the short term, yes, absolutely. They still need traditional legal structures. Look, The on-chain world is maybe worth $1 trillion now. That sounds huge, but it's only about 1% of the global economy. It's not self-sufficient. These projects need to pay employees in dollars or euros, pay taxes, interact with customers who use fiat currency, make traditional investments sometimes. So you need bridges to the off-chain world, and that's where legal wrappers come in.
Legal wrappers.
These are just standard legal entities, companies, foundations that allow the on-chain project to, well, interact with the traditional world, sign contracts, hold bank accounts, deal with regulations. Interestingly, it's often not just one company. You might see a structure with a development company, DevCo, another one for token distribution, maybe a foundation to manage the treasury. It's more like a network than a single top-down corporation.
But what about the long term? I hear people talking about, maybe 5-10 years out, the on-chain economy hits $10 trillion, finds product market fit. Could it reach a point where it doesn't need fiat anymore? Could those legal wrappers become unnecessary?
That's definitely the vision for many builders in the space. The idea is that if the ecosystem becomes large and functional enough, it could operate almost entirely with crypto assets and on-chain governance. And there's an argument connecting to this that these on-chain entities might even be more sustainable because token ownership can be spread much wider. Founders, investors, the team, even users. Everyone holding the token potentially has an incentive for the project to succeed.
Aligning incentives across the board.
Exactly. It potentially bridges that gap you sometimes see between traditional company shareholders and the actual users or customers.
Okay, but this whole code is law idea, it feels like it could run into problems.
No.
What happens if the code isn't perfect? What if there's a bug? Or what if the code does something that, actual law wouldn't allow?
Yeah, and that's where things get really complex. You're hitting on the core tension. Smart contracts might tick the boxes for forming a contract offer, acceptance, consideration, but they might miss specific legal requirements in a particular place, formalities. And there's this critique, sometimes called the Lochner era critique, borrowing from legal history.
Lochner era, right? That was about courts maybe overprotecting contracts, even unfair ones.
Kind of. The concern is that smart contracts, with their automatic, perfect enforcement, could bypass important legal safety nets. Think about doctrines like unconscionability, where a court steps in because a contract term is just outrageously unfair, or public policy rules. These concepts rely on human judgment and interpretation, which are really hard to just code in.
So traditional law often steps in after a problem arises, ex post enforcement.
Right. It allows for discretion. Smart contracts aim for ex-ante enforcement locked in from the start. No wiggle room, which can be good for efficiency, but bad if the outcome is unjust or unforeseen.
And there's the legal realist view too, right? That the state is always kind of in the background setting rules.
Exactly. Legal realism points out the state doesn't just enforce contracts, it sets the background rules. What counts as signing under duress versus freely agreeing? What happens when a contract doesn't cover every possibility? The legal system fills gaps. Smart contracts, being code, often struggle with ambiguity or incompleteness in the same way. They execute what's written, even if it leads to a weird or unfair result in a situation the coders didn't anticipate.
Is there a big example of this kind of clash?
Oh, absolutely. The classic one is the Ethereum DAO hack back in 2016.
Ah, yes, the DAO hack. Big deal at the time.
Huge. Someone exploited a vulnerability, a bug, in the DAO's smart contract code and started draining millions of dollars worth of crypto. Now, according to the code is law purists, that was technically permissible by the code. The code allowed it, so it happened.
But that wasn't the end of the story.
Not at all. The Ethereum community faced a massive dilemma. Stick to the principle of immutable code, or intervene. They ultimately chose to intervene. They executed a hard fork, basically, a software update that rolled back the blockchain's history to before the hack, effectively reversing the transactions.
So much for immutability then.
Well, it showed that even in systems designed around immutable code, human consensus and ideas of fairness can override the code when the stakes are high enough. It revealed that code is law has its limits when it crashes against human values. And this ties into consumer protection, too. If a smart contract automatically takes your money based on unfair or even illegal terms, the self-executing nature makes it really hard to challenge or get recourse.
Yeah, how do you dispute something that's already happened automatically and can't be reversed?
Exactly. And how do you ensure clear disclosure, like consumer law requires, when the contract is complex computer code? These are big, unanswered questions.
Okay, theory is one thing, but let's talk real world. You mentioned a recent court case, CFTC v. Ooki DAO. That sounds like it puts these ideas to the test.
It really does. This case from the U.S. Commodity Futures Trading Commission, the CFTC, is a landmark. Essentially, a federal court decided that Ooki DAO, this decentralized organization, could be treated as an unincorporated association, meaning it could be considered a legal person under the Commodity Exchange Act. So the CFTC could regulate it and take enforcement action against it.
Against the DAO itself,
Yeah.
not just the people involved.
Against the DAO as an entity, which is pretty novel, saying this decentralized network, this code run by a collective, is legally responsible.
And how do they even serve papers on a DAO? Send an email to the blockchain.
Haha. Almost. The court actually said the CFTC could serve the DAO by posting the legal documents, the summons and complaint, on the DAO's online help forum and its discussion chat box.
Seriously, posting on a forum counts as legal service now.
In this specific case, for this DAO, the court allowed it. It shows how legal procedures are trying, maybe awkwardly, to adapt to these new structures. But the implications are the really big part. First, it suggests that technology, when managed collectively, like in a DAO, can be a legal person. That opens the door wide for regulation. Second, it puts everyone involved in DeFi on notice. You can't just say, oh, it's decentralized, no one's in charge, and expect to avoid regulatory scrutiny. Enforcement risk is real.
Okay, but what about individual liability? If the DAO is a person, are the token holders off the hook?
Well, that's the really scary part for token holders. The ruling, and especially a dissent from one of the CFTC commissioners, Commissioner Mersinger, brought up this idea of control person liability.
Control person liability.
Meaning that potentially DAO members who hold tokens and vote on governance proposals, even proposals that seem totally unrelated to the violation the DAO committed, could be held personally liable for the DAO's actions and debts.
Wow, so just by voting on anything, you might be on the hook if the DAO breaks the law somewhere else.
That's the potential implication raised. It suggests that participating in DAO governance isn't just a casual click. It could carry significant personal legal risk. The Ooki DAO ruling didn't just find a way to hold the DAO accountable. It potentially blurred the lines of individual responsibility for everyone involved in its governance. It's a huge signal from regulators.
That's a massive wake-up call for anyone involved in a DAO then. Your vote might count for more than you think in ways you definitely didn't intend.
Exactly. So while the Ooki case provided some clarity regulators can go after DAOs, it also opened up a Pandora's box of questions about individual liability in these decentralized systems. The legal ground is definitely still shifting.
What an incredible journey through this emerging world. We've looked at on-chain law, the mechanics of smart contracts, their potential, but also really wrestled with the tough legal friction points and how real-world courts are starting to grapple with it all.
It's absolutely a space where the technology is racing ahead and the legal frameworks are playing catch-up, trying to find the right balance. And what's so fascinating, I think, is how this challenges our basic ideas about what law is, how governance works, and where responsibility ultimately lies.
Yeah, the lines are definitely getting blurry.
Yeah.
So here's something to chew on as we wrap up. Looking ahead, how much of our legal future will actually be written in code? And how much will always need that human element, interpretation, judgment, maybe even forgiveness? And maybe the biggest question, who gets to write the rules for this new digital frontier? Thanks so much for joining us on this deep dive. Until next time, keep exploring, keep asking questions, and stay well informed.